years ago. Yeah.
Hi, thanks for joining me today. This is Anthony Parent of IRS Medic. And today we're going to be going over all your various options if you have undisclosed accounts overseas, if you are worried about criminal charges, FBAR penalties, all the various disclosures. We're calling this the Offshore Disclosure Guide, all the updates. We're going to tie together all our past presentations on a lot of various programs. And really, one of the reasons why the primary motivation behind this video today is what is still happening as we're speaking. And it's one of the most horrific things that I encounter. And this is the problem that's going on still to this day, is that many tax attorneys are advising people with undisclosed accounts with some civil penalty exposure to still enter into the IRS voluntary disclosure program that's current. That's been current since 2018, and this is the program is really not appropriate for most people. And that's the thing. So Keith, joining me today is Keith Redman, and Keith's going to start off with a story he was just telling me before the show about someone he talked to, and he went to a large, well-known law firm in the United States of America. And Keith, can you tell me, welcome Keith, and also joining us today is John Richardson. And I really want John to hear this story, that hopefully John gets a little bit enraged as I did. So Keith, tell me the story of the person that you talked to recently. Oh, I have you muted. There you go, Keith. Go ahead, Keith.
Yeah, can you hear me okay?
Yep.
Okay. What happened was a few years ago, a gentleman reached out to me because it was suggested that he did. This is a typical accidental American, British mother and French father, or vice versa. And he was born in the U.S., okay, and left when he was in diapers and moved to Europe, and no connections, et cetera. And he got panicked, and because he didn't know anything from anything. And so he reached out to Baker and McKenzie.
Okay. They're a well-known law firm, especially in tax.
Right. And yeah. I have a feeling he reached out to them in Europe, maybe not in the U.S., but nevertheless, reached out to them. And what they proposed to him was that he enter the OVDI, the Offshore Voluntary Disclosure Program.
Right.
And he was in the process of doing that. And I told him, no, stop. Do not enter that program. That is not for you at all. And so he stopped. He paid whatever money's owed to them and absolutely stopped. And what he decided based on our conversation, he chose to just go ahead and get a certificate of loss of nationality and move forward. This was before that special program for certain Americans overseas was around. But that was his choice. But even if he had decided to go into some relief procedure, it definitely wasn't that one. So I was actually quite shocked that it was even proposed, number one. Yeah. And number two, that it was proposed by a very well-known, prestigious law firm. And it just gets me wondering how many other people have gotten sucked into getting into the wrong program. Which could be ruinous.
And it is ruinous. I mean, thank you for that story, Keith. And it is absolutely horrible when it happens. And oftentimes, we'll get the calls from people, hey, this law firm advised me to enter into this voluntary disclosure program. What can I do? And the answer is, well, here's the thing. Once you're in, you can't get out. And it's going to be a long, brutal slog to the end. And, this is really, we'll get into it. And hopefully as we go through this presentation, if you're watching this, you hear Keith's story, maybe you're not I don't understand why the advice was so wrong. At the end of this, you can see why, wait a second, this is totally the wrong program, and it's the wrong mindset. It's really the wrong mindset that's going on. And we're looking at things from a tax compliance standpoint and not a criminal law standpoint, which is sort of missing in here. So with that, hey, John, good morning to you. Are you surprised with Keith's story?
Well, I'm not surprised by the story, but I don't think it's really. I thought we were talking about it today. We're starting off with the long time voluntary disclosure, the standard thing that it has always existed, that existed
Right.
prior. Well, Keith, it sounds to me as though the people who you just described were being told to go into the offshore voluntary disclosure program, which was a different kind of program altogether. I didn't hear anything in that suggested.
Well, I think the terms are, I mean, because of based on the time, there wasn't the offshore voluntary disclosure at the time. I think the term was used interchangeably, which is somewhat of a problem. I think that the terms are used interchangeably. So let's get into it. Let's get into the presentation. This is what we're going to be talking about today and going over, and what the voluntary disclosure program actually is, what John just brought up. Well, what do we mean by that? And we'll get into that a little bit. Then we're going to go over the streamlined disclosures, the foreign and domestic, delinquent FBARs, the DIRFs. We've covered that extensively. And then filing amending returns, so-called soft or quiet disclosures sometimes, simply complying going forward, or lastly, doing nothing. So these are all the things that people do. And so we're going to go over, and these are really these are all the things that come into play. So let's just start off with the voluntary disclosure. And this is what this is really my commentary on this, is that I started my career in doing criminal law. I did that and did criminal defense, and so I'm very familiar with what it takes to get a conviction, and for that conviction to sustain. So when I came into the voluntary disclosure program, I did look at this largely with a criminal through the criminal lens of how the government would prove their case. In 2009, when the first offshore voluntary disclosure initiative was announced, it was designed for people with actual criminal intent. There were about 45,000 account holders with UBS, all or nearly all, who intentionally created the accounts overseas, intentionally did not report them, intentionally did not file FBARs. Actually, they didn't even know about it. And that is what it was designed for. People who really could be held criminally prosecuted. Now, here's the problem the government had at the time. This is why you need to understand why they came up with the program. There were 45,000 account holders. There is no way the U.S. government could indict all of those individuals if they wanted to. There's no way, because just consider there's only about 3,000 it's not even just tax indictments, combined indictments from the Department of Justice, the Tax Criminal Investigation Division. So the IRS had no way to do it, and so they came out with this civil program to avoid the criminal charges, so people could avoid the criminal charges, because if they didn't enter in there, the IRS had them dead to rights. And that's why the program, the 2009 program, was created. It was really designed for those with criminal exposure. Now, what happened was the IRS didn't understand that. The IRS didn't understand that people were in massive noncompliance because it was so complex, and didn't understand, and the tax industry hadn't caught up to speed. So while the IRS created this program for those with criminal exposure, there were no other options. And so what happened is that people who didn't have criminal exposure were basically forced into the OVDP, and simply because there were no other options. And we took many people through the OVDP, and it was not a lot of fun. We did opt out a lot of people from the penalty structure, and we prevailed in mostly every case. But it was a real big disaster because the IRS itself didn't understand the nature of the problem. And then this is the thing that I would say about if you have criminal exposure, you need to do some analysis into exactly why you have criminal exposure. Because look, the IRS cannot indict everybody. And really, one of the things I always find interesting is people like, oh yeah, you better do the voluntary disclosure program. And the question I always have is like, well, who's the person who's going to testify against them? Right. And for most cases, the only person who has bad information on the taxpayer is the taxpayer itself. And so it's a really, I've been seeing this scaremongering to get people into the voluntary disclosure program. And it's heartbreaking. It's heartbreaking when you realize they went into the wrong thing and they stand to lose the bulk of their fortune in a very miserable process by as well, all the while not having any real criminal exposure. Because here's the thing that most tax people don't understand: how trials are won and what the jury is thinking. Let me tell you what the jury is thinking. They have no idea when they convict you of tax evasion that you're going to go to prison. They're not necessarily told that. What they're there is to say, well, does this person owe a bill? And did they not pay it? Well, hey, I pay my taxes and this person has a tax bill. They didn't pay it. So yeah, we'll convict. Tax evasion. That's how a jury thinks about things. Now, this is the problem. Juries are just like Americans, like everybody else, right? They actually don't know that your worldwide income is taxable when you live overseas. They don't know that your worldwide income is taxable. So the jury themselves would be quite confused in many cases, and it's a case that the U.S. Department of Justice simply wouldn't want to bring because the government doesn't want to lose. They want to create an aura of impenetrability, and so they want to go after the easiest cases, and 92% of them end up in a plea agreement because they pick and choose the juiciest cases, and most people are not in that juicy case category. So, this is what I have on the voluntary disclosure. If someone is advising you to use the voluntary disclosure program, ask them about their criminal defense experience, right? Who's going to testify against you? How will the government actually prove their case? Again, prior incarnations of the offshore voluntary disclosure program were for people with limited exposure. There were no other options, and that's why they did it. We haven't advised anyone to enter it since 2017. Now, this is what I would say, and what John was getting to was that the OVDP ended. Now there's just a voluntary disclosure. You can use it for offshore, but now there's just a voluntary disclosure. They ended the OVDP program because it was quite difficult. And I think one of the reasons why is the cases were quite difficult for the IRS to process, and it took a lot of their time. And they were the ones, and this is what would happen. I would call, on one of the cases I took over where someone entered into the OVDP, perhaps were opting out, I would talk to the IRS examiner to say why, and they would ask me this question: why did this taxpayer enter the voluntary disclosure program? And I would just kind of be silent, not say much, and then they'll say, oh, it's because the prior attorney wanted more fees, wasn't it? And, I just generally agree with them because that seemed to be the case. And it's common for people to scare people into this program. So just, again, pick your head up here. There's really not a lot of indictments going on, period. And even incredibly few indictments for involving the people, the claims that are involved here. So now John's got some points on this, and we want to bring the great John Richardson up here. Well, actually, here's one. Here's a hypothetical, and I'm like, okay, so what is there a situation, John? Tell me if this is a situation where you might advise someone to enter into a voluntary disclosure program. I was really trying to think of some facts where it's like, okay, yeah, maybe this would be it. So let's say Rod lived in the U.S. and intentionally avoided payment on U.S. taxes by transferring pre-tax dollars overseas to a foreign bank account. Rod filed returns, but specifically did not include income earned overseas. He knew about the FBAR and specifically did not file one. Rod has heard that the bank he is using is under criminal investigation by the Department of Justice. Rod is concerned that it is merely a matter of time until the Department of Justice finds him. But as of yet, the investigation is only against his bank. Can Rod use the voluntary disclosure program? John, what would you say about that? Because to me, I'm like, yeah, this might be a situation. Because again, we have the overt act. We have a tax return that left off the income. And the other problem we have is we have a bank. We have a bank that could testify against you. Someone at the bank could testify against you. So I see the government having a case. Now, this is the thing, too. There's no investigation against Rod personally, so he can still do it. If an investigation starts, you cannot use the voluntary disclosure program. You got to figure out another way. So, John, would you say maybe this is a situation where the current iteration of the voluntary disclosure program could possibly be appropriate?
So I'm going to answer the question this way. Okay. When I look at this, these various options, the history of this, I am very predisposed against voluntary disclosure. Okay. Generally, and we'll get to this set of facts in a minute. But the reason that I'm predisposed, here are the reasons, okay? First of all, you're knocking on the door of the Internal Revenue Service, introducing yourself as a criminal.
I have your slide here. I had your slide. Here we go. This is your slide. Yeah. Yeah. Go ahead, John.
Okay. You're introducing yourself as a criminal. Now, a lot of the, okay, let's be very, very careful here in this discussion, okay, to make a clear distinction between the offshore voluntary disclosure program that was ended in 2018 and traditional voluntary disclosure that's always been around. Okay. Right. It's always been around. Okay. And continues to be around. What I found most interesting in 2018, when the offshore voluntary disclosure program was ended, was the extent to which the IRS seemed to bend over backwards to make it clear that ending the offshore voluntary disclosure program was not a signal, absolutely not a signal, that people should be entering voluntary disclosure, the traditional voluntary disclosure. So I think this is really, really important. Strong messaging and signaling from the IRS in 2018. I'm not aware of anything since saying, hold on, be careful here. Okay, this is not for everybody. And they make it clear that it's for a very specific type of person. Now, the other thing they actually said in the memo there, and this is by memory, so you want to check it again, but I think there's even a part of the memo that says you can always clean up your problems by just filing. Okay, but check that out. And my DNA on this stuff is, why don't we start with the principle of what is the status of your non-compliance? How or why are you not compliant? And maybe just figure out, just file the stuff and get into compliance. Amend the damn returns if possible.
And John, that's kind of, because when I go back to my hypothetical right here, where did I put it here? My hypothetical right here, I'm still saying, I'm like, well, there's no investigation against Rod yet. So if he just amends his return to include all of his income, files any FBARs, what has happened? Has his civil penalty exposure been reduced? No, it hasn't. But has his criminal exposure been reduced? And the answer is, oh God, yes. Oh my God, now the case stinks. Now the IRS has to bring a case. Well, here's a taxpayer who on his own corrected his returns. So what do you do? What do you do? How do you explain this to, can you get an indictment from a grand jury? Sure. But now you have a problem trying to prove a very difficult case where someone went on his own to cure his defect. And now you're going to claim that person was committing tax evasion. It's an ugly case. And why go after that case when they have other ones? And so I thank you for that, John, because I that's exactly right. Why don't we just file?
Yeah. So I think this is so important. We talk about all these programs, and I think it's easy for people to, get sucked into the idea that U.S. tax compliance is about selecting which program, and it's not. U.S. tax compliance is about compliance with the law. Okay. And, and it's always, in many cases, I think the best option is just, or at least the first option, maybe not the best, but the first option should be, where's the non-compliance and why not just fix it?
Right.
Okay. And, obviously this is completely dependent on the facts, but I would start with that. Okay. But back to your question.
Yeah, go ahead, John. Go ahead. Yep.
Back to your question about would I enter the voluntary disclosure program? The reason that I'm so against this presumptively, although obviously there are cases where it's appropriate, right? But the reason why, let me put it this way, under no circumstances should voluntary disclosure be used as just one more way of tax compliance. Okay. I think that is certified.
There you go. Yeah.
Because what you've done is you've announced yourself as a criminal. Okay. And that's, that it seems to me is a bad thing in life. Okay. To do that. Now, the second point that I would make here generally is this, that when we're into criminal tax stuff, and this is by no means something that I'm an expert on, and therefore anybody listening should interpret this to be perhaps the start of the conversation and not, definitive on anything. But criminal tax convictions require proof of a very specific, no pun intended, kind of intent. Okay. And there's a case on this that I think is still the governing case, the Cheeks case from 1991, the U.S. Supreme Court, kind of lays this out, right? And because a very high standard of intent is required, all right, a lot of people sort of panic because they've done something wrong, and they see in hindsight they've done something wrong. But that's not so much the issue. The issue is what was going on at the time in terms of what actually was intended or not, right? And that's also very important. Don't confuse the way you feel about the problem with, you know, what are the things that need to be proven, you know, for there to be a criminal conviction, etc. Those are very different things, okay? So I would start off with, let's solve our problem. They want us to be in compliance with the law. Let's figure out how to do that, okay? You know, if possible, without saying, hi, I'm a criminal, okay? But I think what's so critically important here, okay, is the following, that, you know, I don't mind, you know, I mean, it's fun to do these kinds of discussions mostly, but I want to make the point that I don't think there's anybody in this discussion today who's a full-time criminal tax lawyer, you know, sort of thing, right? And nobody should enter the voluntary disclosure program without seeking an appropriate advisor.
Yeah.
And let me tell you who is not an appropriate advisor. The tax preparer, the accountant. Okay. Yeah. You know, I would not even call those people up to see what they think, because all you're doing is giving them information that is probably better they don't have anyway, right? I mean, this is a situation where, I don't know what's the noise in the background.
I think that's Keith.
That's me, because I was going to ask a question, John.
You know, this is a situation where you do need lawyer-client privilege. Number one, you need it because you need to give full disclosure of the facts to somebody. And who are you giving the disclosure of the facts to? It's somebody who is a criminal lawyer with some kind of experience in tax. Now, those people are not on every street corner, but you need to find that kind of person. And the absolute, now this is, I want to preface this with, this is my opinion only, and therefore people will disagree, and maybe I'm wrong, but I don't think I'm wrong. The worst person to call is the accountant.
Yeah.
Okay. On this, I mean, they don't have, you know, they don't do that kind of stuff, right?
Yeah. And John, this is what I would say too, because, you know, I took a call from a friend of mine who's an enrolled agent, and he said, "Oh yeah, I have a client who hasn't filed taxes in years and didn't report his income. And I belong to this networking group, and this attorney advised him to enter into the voluntary disclosure program." I said, well, why are we doing that? Why don't we just get into compliance? Is there a reason why we believe an indictment is coming? And, you know, there was no response. I'm like, no, we don't need to do the voluntary disclosure program. Just get them into compliance, save them some money, and just get it done quickly. It's time. The speed is your friend in this case, not throwing yourself upon the IRS. That is not the solution. And the other thing I would mention too is that I have people who call in to become my clients who are targets of IRS criminal investigations. I do it. I help people out. And so what's my strategy when someone comes in to say, yeah, I got a target letter from the IRS. Yeah, the IRS is going to indictment. What's my strategy? It doesn't work in every case. It doesn't, and it takes a little bit of skill. But I can tell you this, in some situations, we have simply negotiated with IRS Criminal Investigation Division. And what we have is that if a criminal case is a lot of work for them. So if I'm able to get in there in time, say, hey, I understand my client received a target letter. Curious how much time you have into this case. If they say they have a lot of time, that's bad. If they say, just kind of open up the file, that's good. That's good. Now I might be able to contact them. It's like, well, hey, look, I reviewed these things. It looks like my client should really amend his returns. Is that something you'd be okay with? And sometimes you do it anyway because you don't need IRS criminal investigations division's permission to be in compliance. And that's number one. That's usually the number one issue that I see from people is they're looking for permission to be in compliance. Like, no, the law mandates you need to be in compliance to the best of your ability. There's nothing about a potential investigation that suspends that duty. So those are the things those are generally what I see in this, is that even if you were in criminal indictment, it could still be saved. It depends on what your attitude is, and it depends on what the IRS has against you. If they don't have the witnesses, if they don't have the witnesses who are going to give them everything they need, well, where's the case really going to go? Now, Keith, you wanted to ask a question?
Yeah, I just wanted to interject. So, but based on what John was saying and what you were saying, the appropriate people to go to. So,
Yeah.
what happens if you go to like like the gentleman I was speaking of earlier? What happens if he goes to a lawyer like with Baker and McKenzie and they give him wrong advice?
Yeah.
Would you suggest that they get a second opinion?
Oh God, yeah. I mean, absolutely, because it's one of the worst things to be. It's one of the worst things to happen to you. And I would say this: if someone's looking for that opinion, they just go to irsmedic.com offshore, and we'll have a confidential discussion about ways forward, because it's really awful once you're in there, and it's a nightmare. And I mean, you are just used every which way. The penalties come at you every which way, and then the legal fees come at you every which way, because really what you're doing is that you are creating at least a 6-year examination of everything. So you're going to, that if you think an audit is terrible, well, guess what? You're doing a 6-year audit on yourself, saying, hey, audit me, guys. So you have to create those audit reports if you want to win. Now, if you don't care, well, then do what you want to do. But even there, you need you need a substantial effort. So, I mean, the amount of time that is required just alone, let alone the fees, is monstrous to do this. And so again, I just see again and again where people are given this mistaken advice that a voluntary disclosure will somehow give them a benefit that just normal compliance won't. Appreciate that. Go ahead, John.
Here's what the problem is. Okay. It's not, there are large law firms that give bad advice. There are large accounting firms. I mean, nobody has a monopoly on good or bad advice. That's right. Sure. And there's also nothing about, being a tax expert or a tax compliance person that has really anything at all to do with this. And I think that I want to make that point upside down, sideways, and diagonally, okay? Because we live in this world where so much of life is tax that people think, they call up any tax person, they're going to get good advice. Now, where the work needs to be done, and here's the advice that I would give somebody, okay, that I often give people in this, not the criminal context, because those people generally don't, they rarely, if ever, do they call me. But the advice that I would give is that the work you need to do is in finding the right advisor for you. That's the work, not saying, well, ABC law firm does tax, therefore I will call them. That is where the mistake is, okay? So, the question, that's the first thing, okay, is that you need to find, principle one, you need to find the right kind of advisor, and that's not necessarily easy to do. But what you're looking for is somebody who with experience is essentially somebody with a background in criminal law who also applies this in the context of tax. That's the first thing. The second mistake that people make here, and this is unreal and almost always leads to trouble, is getting second opinions, third opinions, fourth opinions, fifth opinions. Where you need to do the work is on identifying somebody who you think is worth having a conversation with, if you want to get another conversation, maybe one more, okay, but this is where the work is. You do not shop the market, you know, hoping to find somebody to say something that you happen to like, you know, when all of this information is coming from people who, you know, really have no particular experience in this. The third point I would make on this is in finding an advisor for something as consequential as this is find somebody whose judgment you generally feel you can trust. You know, you can't get right and wrong answers here, okay? But you can generally identify, you know, people whose judgment that you trust, okay, you know, on this type of thing. Next, all right, I think generally, I have seen, now this is a generalization, perhaps too much of a generalization, but I've seen this as a problem over the years. That I think that if you're not living in the United States, you know, that is an American abroad, okay, even if you identify somebody in the United States who you want to start off with, I would get an opinion from somebody outside the United States as well, because, you know, this stuff, you know, often implicates things that are related to your tax situation outside the United States. In addition, you know, people inside the United States have a very, very American-centric view of this, which often is narrower, you know, than I think it should be. You know, I think that people inside the United States are much more prone to reflexively want to put people in programs, you know, than perhaps, you know, think more broadly. So maybe I'll stop there because maybe that's too much. But my message to anybody listening to this is that it's not so much the advice given, or that, you know, you can get that anywhere. It's who the advisor is. Okay, and that's where you need to do your work up front.
Yeah,
okay?
no, and I would say, John, thank you for that. And I would say for myself, what I've noticed is that, you know, you want to have, you know, a firm that aligns with your values. And I think that where in this, you know, in this our podcast that we have has been fantastic, because what I'm told constantly by people is that, you know, I really appreciate your approach to this. That we're looking at it in, you know, I think we you know, us three actually know what the income tax actually is. You know, it's not about revenue, it's about control. And once you understand that, once you understand what the U.S. income tax actually is, now you can formulate the best strategies. Once you understand what the IRS is trying to do with IRS Criminal Investigations Division, once you understand that actually what all that IRS Criminal Investigations is, really, it's a press releases, because the IRS doesn't care about anything they collect in criminal cases. That's all. They don't care. All they're trying to do is get a press release to scare everybody into compliance. And so if you understand that the IRS, if you can make the facts in your case terrible for a press release, that's actually a huge way to win a case. And so I would say that it is difficult to find. And I do appreciate what we've been discussing over the years, because it's helped, I think, explain our philosophy, and people really identify with that. And I would say that, you know, the tax industry generally looks at people as just not people, not just like, okay, here's someone who's insensitive to prices and they don't care, so we'll just jack them for whatever it is and we'll get through them. Who cares? They have to pay it. They don't have any choice. So that you do run into that. And I do think you got to find somebody who you agree with, whose philosophy you agree with, because ultimately, and this is the thing, you are responsible. The law doesn't allow your tax professional to be the one who's primary liable. They may do something, they rarely ever do, but rather they go after you, the taxpayer. So you've got to make sure that the values of your professional line up with you. Otherwise, you can get a And I'd say this is here we go. Thank you, Burchell. Advice is everywhere, right? But resolution is not. And a lot of the advice out there is a lot of scaremongering in order to generate fees, unfortunately.
So let me ask you a question, please.
Go ahead, Keith.
So let's just So the gentleman I spoke to at the beginning of our podcast,
Yep.
what, he talked to me, so that was a good thing. But let's say he didn't have me around, okay?
Yep.
What should he have done as far as his due diligence so that he would not have gotten sucked into getting into that offshore voluntary disclosure program? Is there something that was missing in his investigation?
Yes, there was.
Right.
I have a very quick
And
answer for you.
keep in mind, you have to have the mindset that this gentleman knew nothing about the U.S. tax system or anything at all. He's a foreigner, okay?
Yep.
So what guidance would you give somebody like that before they secure somebody so they don't get wrong information?
So what I would say is that the number one thing that he missed out in his investigation is a thing called YouTube. And if he just stumbled around, he would eventually come across our channel because we have so much content on it. And during that, in our long discussions, they are long.
Well, today he could do that, but this is a number of years ago.
But right, I mean, so I would just suggest you have to, get to this channel. I don't know another way to say it. Because we are unique. And I would say we are unique. There's other great professionals out there. I know them, but no one else is out there on this particular topic, taking such a leadership position as we are. So I would just say, I just got to, we're the solution to that problem. I would say, Keith.
Right.
But I don't know how to tell someone who isn't watching us to watch us. Right. So that's my job. That's our job to promote it better, I guess. To promote the channel better. And then if you are someone who's watching, if you are a fan of this channel, then I would just say, please share it. Please share this and like it and get this, because this is the way that YouTube works is the more likes, the more watches, the better the rankings, and the more, and that's why we really want to have a real community here, because the videos will rank better and better. And then the real, the more important information will get out there, and the other sales pitches just kind of go down. The scaremongering sales pitches, which are oftentimes just a regurgitation of some IRS training that may or may not be based in reality. So that's what I would say about that. I do want to get into the other options very quickly.
Yeah, just 1 second, Anthony. Keith.
Yeah.
Let me float this idea. I'm not sure how you solve this exactly, okay? But here's the nub of the problem. That, I've said this for years. I'm going to say it again. We are not today talking about tax problems in the least. We are not talking about tax problems in the least. We are talking about compliance problems or non-compliance problems, okay?
Yep.
They're completely different things. The reason you don't call an accountant in this type of situation is because they deal with tax, filling out forms, how much? Did they deal with compliance? Okay, they may think they do, but they don't. Okay, because that's a much more nuanced thing. And one reason that we know they don't deal with compliance is because somebody who really does this kind of work is going to understand that this is not about tax. It is about compliance, but the resolution is helping you to move forward with your life and put this behind you. That involves understanding something about your life. Okay. Family, inheritances. I mean, all kinds of things, because it's very difficult to. The reason that, there's so much boilerplate advice out there or suggestions is because it's a substitute for trying to understand what your circumstances really are.
Right. Yeah.
So again, I mean, maybe in your group, Keith, you begin to preach the gospel that that a compliance problem is different from a tax problem.
And if I could just sort of articulate, because I thank you, John, for that, because you're absolutely right. And this is what I would say is just, think about this, like you could owe millions of dollars to the IRS and still be in 100% compliance.
That's right.
Yep. That's right. You can be in 100% compliance. It's just complying. Okay, I can't afford to pay. Okay, well, what are you going to do? Well, I'll submit a 433A and come up with some settlement. Okay, the IRS accepts it. Okay, you're in compliance. Or you just getting a hardship status. You're in compliance. The IRS is okay. Here's a taxpayer in compliance. even though you have a massive, massive liability potentially hanging over your head. So great point, John. I appreciate that. So let's get to I think we're gonna go through the other options pretty quickly because we do have, and again, I did upload these slides. If you go to the video description of YouTube, and I just uploaded it on Twitter, you can go to at IRS_medic at Twitter. You can find these slides there too. So just quickly, we're just going to go over, generally who Streamlined is for. And the question is that most people qualify for Streamlined. The standard is I didn't do it intentionally. Negligence is fine. Negligence and probably even recklessness is fine. Most people can even probably qualify for a subsequent Streamline. We've done it, and it's not an issue. Again, the standard is I didn't do it intentionally. So it can happen again. You're looking for both unreported income and missing forms. If the income is reported, we look to the DIRF or Delinquent FBARs. We'll talk about that a little bit. If the form is incorrect, maybe we just look to amend. If overseas, there is no penalty, and if you do live in the U.S., there's a 5% penalty. And also the transition tax is a requirement, which is a little nasty thing if you happen to have stock in a foreign company with built up EMP. These are some of the things we don't have time to get in all of. Those are some of the things that we're going to be looking for a streamlined disclosure generally. Here's a quick hypothetical. In 2017, Charles lives overseas, filed a streamlined disclosure, but life got the best of him, and he fell into his old ways of noncompliance and didn't file his returns from 2020 onwards. Can he file the use a streamlined program? Absolutely, we've done it. Again, the standard is non-willful. That hey, look, life got in the way, COVID happened, moved around, I couldn't find a preparer. That's reasonable, or not. Actually, that's non-willfulness. It might not be reasonable cause, but that's not the standard. It's non-willfulness is the standard. Here, I don't know if we have time to get into this one. And another thing is this. Here's another quick hypothetical. I was talking to my client. I mentioned this. I changed the facts. I told him yesterday. I said, you're going to be on the show today. Here, Dean lives in the U.S. and filed all his returns. He had no foreign bank accounts to report, but on his Form 8938, he substantially understated the value of his foreign stock he owned. Additionally, he did not report any of this income on his tax return. Changing some facts here, by the way, the value of the stocks is $10 million USD. Assume there are no tax credits to apply. Should he use the streamlined program? And then we want to assume there are tax credits to apply. And in this case, he lives in the U.S., so he's subject to a 5% penalty. Now, this is what people fail to do. The reason why I put this hypothetical up there is they fail to analyze the true risks. In this case, there is no risk of criminal prosecution. I told them, look, maybe you have a risk of criminal prosecution, but it's for something other than your taxes. It's not here. It's just simply not here. It was an oversight. It's not a big deal. So the question is should he enter into the streamlined program? Because he's going to have a 5% penalty on his stock. Well, then we said, I asked, what if we just amend your returns with the Form 8938 outside of the streamlined program? What's your penalty exposure? If you get detected in an examination and then we've calculated it, we calculated his maximum penalty exposure as being $140,000, and that's maximum. And that's assuming everything goes badly for him. Whereas the 5% penalty that the IRS wants them to pay would be somewhere around $500,000 in this case.
Wow.
So why throw wait a second, are you at risk for criminal prosecution? No. So why would you give $500,000 to the IRS? Because of the possibility that you might be assessed $140,000 in penalties. And that's where people aren't really, they're just, I got to do it. But they're not looking at,
There's a lack of critical thought and analysis that has to be done.
And there's no substitute for that in-depth analysis on everything. And there's so many moving pieces.
So, Anthony.
Yeah, go ahead, John.
Do you get that kind of analysis from a tax preparer?
No, you will not get that kind of analysis from a tax preparer. They're going to tell you
a chance of it, right? Zero.
No way. No, they're going to say you got to do it because look, and they'll throw out the criminal charges. Well, it's a criminal thing, not the no. In this case, there is such little risk And because the unreported income in this part was not all that much. It was not as all that much relative to the value of the stock. And if you pay the taxes, what's the crime? Where's the crime? You're in compliance. You're in compliance.
Anthony, is it ever a bad thing to be in compliance? Is it ever a bad thing?
It's never a bad thing to be in compliance.
Yeah,
right,
right. I think that's an important message. Yeah.
Yeah. And by I gotta just pop up. I love this comment. Saint Sanjay, thank you so much for this. I wish the Treasury IRS chief watched this show. Yeah, I do too. We'd have a little bit of a different world. I don't know. Maybe they'd look to shut it down.
Hey! I got to ask you a question, guys, because it's an interesting statement that you just made. So you said it's never a bad thing to be in compliance.
Yeah.
But I've heard on previous podcasts, or maybe it was just another conversation I had, is that those who have problems are the ones who are in compliance, not the ones who are not in compliance. So why is like for example, the transition tax?
Because Keith, unfortunately, we live in a world of laws. Okay. And
yeah, I know. I hear you.
And it's. I mean, I hate to say it's the law, but look, I think it's important. I mean, obviously, everybody on the planet would be better off if they, if these laws didn't exist and therefore they did not do the things that the laws required that caused them so much pain. Of course, everybody would agree with that. Okay?
Yeah, and I sometimes we do speak a little bit of hyperbole. Because not all roads.
Hyperbole. It's not hyperbole. Right. Obviously, tax laws are designed so that when people can comply, they suffer. Okay.
Yeah.
Obviously, all around the world. Okay.
Right.
So there's no question. There's no question that people who comply are, in that sense, worse off. But the problem is, Keith, that non-compliance carries such deep emotional, psychological costs and societal problems for people.
Right.
That's what I mean. I think Anthony means when he says it's never a bad thing to be in compliance.
Never, right, and that's the thing. And and there's nothing, and that's always something that I've gotten. And it was really I had my beliefs for a bit. And then years ago, and this was because I was sort of unique when the 2000 the OVDP came out. I'm like, guys, let's really think about this. I remember I put a post on one of the forums on LinkedIn, and I got hammered by every U.S. tax professional. But then someone who I became friends with stuck up for me and said, no, Anthony's completely right. And then I looked up the guy who said that. It was this guy, Michael Mins. I said, well, who's Michael Mins? I looked him up. Oh, he's just only one of the best criminal tax defense attorneys of all time. He loves getting acquittals. And so started a friendship with him. And I've sent cases to him. He sends cases to me. And so I've learned so much about actually what happens in trial. And that's the thing that we always say. That was the thing that we said, well, what's the thing? Compliance is your obligation. What's the thing about a criminal indictment that ends your compliance obligations? Just get in compliance. Does that destroy their criminal case? Oh, well, too bad if it does. You have a duty to be in compliance.
I'm sorry. I hear you guys. I just have a different view of it. I really do. But if there are people that
what is your view? Well,
here it is. And this is the sole purpose. And this is what I gave. You're right. The sole purpose of the IRS is to punish you.
Right.
So you're going to be punished no matter what. If you're in compliance, okay, you have this things to deal with. If you're not in compliance, oh boy, you got to.
But there are people who have, I know them personally, and also obviously with the people I speak to, who have not been in compliance for 30, 40, and one lady I know 50 years. Okay. Yep. And they will never be in compliance. All right. That's one example. The other example is, with this transition tax. So guess who got screwed?
Yes.
It's the people who have the small to medium-sized businesses outside the U.S., and they were being a good American and being in compliance, and they got screwed with the transition tax. Guess which people breathed a sigh of relief? Those with small to medium-sized businesses outside the U.S. who stayed away from the U.S. tax system.
Yeah.
So where's the incentive for them to come into compliance knowing that there's a transition tax and moving forward guilty?
And Keith, the answer is there's some reason. The answer is yeah, I don't want to do it, but there's a compelling reason. Usually some risk, can't sleep at night. There's something back in the U.S.
I agree. I agree.
It's there.
I agree. If people feel that they have the sword of Damocles hanging over their head and they can't handle it, absolutely, you do what you got to do to sleep at night.
Yeah, yeah.
But there are those who can sleep at night by staying away.
Well, sure. And I'm not there to wake those people up. I mean,
those are people, look, in fairness, those are people who've never been in the tax system. Keith was talking about,
right?
And for the most part, hold on. Yeah. Look, I think the context of this discussion today is people who have been in the tax system and have.
Well, we'll get to people who aren't though. We'll talk about some of those options.
Well, those people who've never been in the tax system, we should not be talking about them in any program that talks about voluntary disclosure.
Right. Exactly. Right.
I mean, that's just so idiotic. Okay.
Yep. All right. Okay. Barshel has it. Summary: being compliant is less painful procedure than not being compliant. That's what it comes down to. And
the person's circumstances. Not always, but look, at some point, I think, we've got to make a decision here, right?
What's that?
Are we talking about, how to best navigate this stuff within the framework of what the laws are, which is one thing, which is, I think, what we're talking about today.
Okay.
Or why don't we have a separate discussion, of whether, yes, we have the laws, and then we do some case studies and determine whether people are better off complying with those laws or not. That's a completely separate discussion. And my guess is that everybody on the planet is better off not complying with tax laws, because the whole purpose of tax is to take your assets. I mean, that's not difficult. It's not controversial, is it?
Right? Isn't it? Aren't you punished by paying your taxes? Right? I mean, really?
Yeah. So I just want to make it clear on this podcast. I am not against tax compliance with the U.S. I'm not. I just look at it as based on the person's profile and circumstances.
Well, no, Keith, that's what we're going to get to, and I think that's the point I want to get to as we conclude. I just want to answer a question here for Barshel asked. That's understanding before we move on. So, if you live abroad, 5% penalty does not apply. One more motivating factor to move overseas. And by the way, Barshel, all you need is one qualifying year overseas. So, not telling people what to do, but
3 years, one of the three,
only need one. So it's an interesting proposal. I want to move on to some of the other ones, because the point of what we're trying to show today is the multiple of compliance options people have, and so we're just going to briefly talk about some of the other ones, and we've discussed these in detail, and you can find those links in the slides, which is linked in the description here. So let's get back to the delinquent FBARs. And I'll just go over this very quickly. The Delinquent FBAR is a pretty good program. If you just have missing FBARs, no reported income, you just file your missing FBARs. And this is good for people who are just mere signatory authorities. No problems with this. We haven't had any problems filing delinquent FBARs. And likewise, and where we go with delinquent FBARs, if someone's in the U.S., they're subject to the 5% penalty. We're looking, hey, could they just do delinquent FBARs? Likewise, as the IRS does not mistakenly assess FBAR penalties, they do in certain situations with 3520 and 3520A penalties. And that brings me to the next one, the DIRF, the Delinquent Information Return Forms. We just covered this last week in detail. The DIRF unfortunately works, but not as consistently as the delinquent FBARs. We still have clients who are mistakenly assessed 3520 penalties even after they go through the program. We're still there. We fight them. We get them away, but it is a pain because it could be outstanding for a bit. And it's a little stressful to see, hey, look, I just followed your advice, Anthony, and I filed my delinquent 3520 using reasonable cause. Why am I looking at a $10,000 penalty for 2 years on this? And I don't like that myself either. So I really wish the IRS, could get its stuff together and not negate the things that they're saying online to do. I really wish they would get to that. And now here's, John, you love this one. This is the relief for former citizens. And I wanted to bring this up as a complete sort of opposite of the voluntary disclosure program that many accidental Americans are in. And so this is one, John, you like this program. This is actually one you like. So John, you want to tell me why you like this program a little bit and who it's for?
Well, this is for people who renounce or have renounced U.S. citizenship or relinquished after March 18th, 2010. The date that FATCA was enacted, who one, have never filed a U.S. tax return as a resident, meaning a 1040, a resident or citizen. Two, have a total U.S. tax liability, had they filed, of under $25,000 for the 6-year period. Three, have a net worth under $2 million. I mean, it's simply unbelievable. Okay, and it has other features that if you have PFIX, you don't have to file 8621s. You just, report the income as ordinary income. There's no certification of non-willfulness required, even though you're supposed to be non-willful. There's no requirement of FBARs. I mean, it's such an amazing deal that, we debated this last time. I mean, I hate to go against the prevailing currents on this channel, but, I think that anybody who has the opportunity to do this who doesn't is a complete idiot. I mean, you don't even need a social security number. I mean, it closes off all possibilities of any problems down the road. And the most important, it means you're not a covered expatriate. So if you happen to have kids who are U.S. citizens or green card holders, they're not covered. They're not subject to the covered gift rules. I mean, I don't know what more the IRS could do, to invent a program, to sort of wink, get people out of the system,
yes,
in compliance with U.S. tax laws. But yet, no.
You get people, and I would say this. Here's the problem with the relief for former citizens, and why I think the program isn't used as much. Not as many fees. You're going to get in and out, and I mean, with us, under 10 grand with us, to get in and out. Whereas, representing someone in a full voluntary disclosure, it's probably going to be over $100,000.
They have nothing. Those have nothing to do with each other. Why are we even talking about those in the same? Look, the voluntary disclosure program is to solve a compliance problem. Okay, the relief procedure to check some boxes, to make sure you're not a covered expatriate. You move on with your life. They have nothing to do with each other.
Yeah. So that is. So,
would you agree on that special program that a lot of tax compliance professionals don't know about it? I found that.
Yes, I would agree. I would agree because tax compliance people, the value of their business depends on the number of the clients they have on a year-to-year basis. And these are not pre-existing clients. These are just, you get in, you get
one
out.
And done, right? One and done, right?
Is more in the context of expatriation work, etc.
Yeah.
Look.
All right, so let me ask you a question, John, and I'm not trying to get the ire of the two of you. You know me.
I don't have any personal stake in this whatsoever.
No, that's fine. So my question is there a situation where it's not a good idea to do that special amnesty program after renouncing?
No.
And your idea?
No, because if you qualify for it, if you meet the qualifications, you're under $2 million. To use it, you have to have under $25,000 of U.S. tax owing. If you meet the qualifications, if the door is open, you walk through.
Yeah.
Okay. I mean, it's the fact of meeting the qualifications that makes it such a fantastic deal.
Yeah.
I mean, I think here's the problem. Okay, largely, and I realize this, listening to this conversation today, is that. So why don't we close our eyes, everybody? In the world, if you're a U.S. citizen, we are all out there in a lifeboat. In a storm. In an ocean of non-compliance. Everybody. Okay? So we start from that. Then what we have all these islands here. We have the island of Streamlined.
Okay.
We have the island of delinquent information, right? We have all of these things we're sort of trying to get to, all right? And after a while, because these are all varying islands, people think they're the same things, and they're not the same things at all. They're very different things for different kinds of people. So it's like, how many main oceans are there? 7 oceans? Or how many continents are there? I can't remember. But let's say we have 6, 7, 8 continents. Every one of these programs should be seen as a different continent and not part of the same. You know, what's the conclusion from this? I mean, you know, find an advisor who understands this person doing the taxes. The tax preparer should be somebody involved in, you know, trying to decide what you're going to do, you know, and live happily. I mean, it's, you know, it's getting increasingly difficult to see how anybody can live under these regulations, but that's a different issue.
All right. Hey, well, fantastic. All right. So let's get to some of the last ones here. Thank you so much, John. And so, hold on, right there. Here we go. So this is what we just talked about, getting in compliance. We talked about this, just filing missing returns, correcting them. This has been deemed as sometimes a quiet or soft disclosure. The IRS was very opposed to people doing this early on because they felt they were missing out on their penalty bonanza. But really, there's nothing to stop you from just being in compliance. And if you are in compliance, it's really difficult to charge you with a criminal charge, even if at one point you weren't in compliance. And so that's what I would say. That's one thing that's always an option to do. There's nothing that suspends your obligation to be in compliance.
So here's what.
Go ahead, Keith. Yep.
Here's what comes up a lot with me is, so you have someone who is a young man, let's say, and he hasn't been in the U.S. tax system, and he got a job offer in the United States, and, he's a U.S. citizen, and he's going to go to the United States. Should he just start complying when he goes to the U.S., or should he enter one of the relief programs prior?
I would
going to be based on his profile.
Yeah, I mean, I'm not going to give a hard and fast answer. Typically in something like that, of like, well, why don't we do a streamlined ASAP, because you're still foreign and there's not going to be a penalty. So that's where I would go. That's going to be my inclination.
Generally speaking.
And then I'm going to be looking to disprove that. I'm like, okay, why is that going to be a bad idea? So that's going to be my first instinct, but then I'll try to say, okay, is there a better option available? So, you know, I think that's an example where you do want to go a little bit deeper, because there could be some other things that would say, actually, we should do something else. So thanks.
One thing I would add to that is, remember that the predicate for streamlined offshore is one of the last 3 years you met the requirements. Nothing stops these people from moving to the United States first and then doing a offshore stream.
Because we have a qualifying year, right? He can move, and we can still do foreign, because he's still going to have at least one qualifying year.
But hey, I got an idea. This is precisely the type of thing where people need to get a competent advisor, isn't it? Right? And here we go. Absolutely. You know, looking for.
Here we go. Yeah. I think. My hand just slipped on this button here. Yeah, if you need a competent advisor, irismedic.com/offshore. All right, so let's get to the last of what we have here. Let's see here. Compliance going forward. We're just talking about that. And I would say this on compliance going forward quickly. Compliance going forward on FBARs, it might be okay, because the IRS has a limited amount of time to assess those penalties if you don't file. On the other forms, you know, the 3520s, if we're doing the DIRF, 3528, 5471, to mention a few, the IRS has an unlimited amount of time if you don't file it, or they deem it to be substantially incomplete. So it's just something to think about. And then, you know, people ask the question, does it raise red flags? And the answer is, yeah, it really might. So that's something we have to think about, because like, you didn't have this thing, then all of a sudden you had that thing. So it can raise red flags. And so that's just part of the things that go into our calculus. Then how about this one, Keith? Doing nothing. Is that an option for people? I mean, what do you think about doing nothing here? And these are,
go ahead. What I say? I just say it's based on the person's profile and circumstances.
Yeah.
And the key questions need to be asked.
Yeah, and here's some things that we go off. And again, you know, I cannot advise you to do.
No, of course, you guys.
But right, maybe this would be a great time to segue to if you are wondering what you should do. Should doing nothing be your option? Well, I do have someone you could reach out to. He's on right here. His name is Keith Redmond. And you could reach out to Keith at US_overseas_advocate@outlook.com. He can kind of guide you through, get some of the important facts for you to whether or not you should take some action of getting to compliance. You're probably not going to advise the voluntary disclosure program, that right? I don't imagine.
Right, exactly. I never tell people not to do anything. I just present to them and talk about all the options and the risks for each one of them. They decide.
Right on, right on. And I think we're coming up on time here, and I do want to just get out a big shout out to John, of course. If you are considering renouncing, and John has definitely taken through many more people through the relief procedures for former Americans or former citizens. So if that's something that you're thinking of doing, I'd really let's get this one here. Get this one right here is, John. I don't think you can get better than John. So if it's something that you're thinking might be a great option for you, reach out to John at citizenshipsolutions@protonmail.com. And otherwise, if you are looking for that incredible tax advisor of who understands criminal law, who has experience with it, and who has guided thousands of people through this difficult program successfully, you can reach out to me at irsmedic.com/offshore. We schedule time to speak about your situation under the attorney-client privilege. No matter who you speak to at my firm, the attorney-client privilege attaches, and we'll come up with the best strategy for you. All right.
I think another thing that you offer, Anthony, and correct me if I'm wrong, is also future tax planning.
There we
go.
What people
need to do moving forward,
and
to help them have a strategy long term.
And that is often helps people decide what path to go. What's the long-term plan going to be? Oftentimes it's like this, Keith, people's like, oh my God, I can't, these taxes are killing me. The compliance is killing me. Well, sometimes we can find solutions to make their tax burden lower, in the terms of filing and their tax rate as well. So that could sometimes take the sting out of, okay, I guess because people reluctantly come into compliance, but if they're saying, okay, well, what's the upside to it? It might not be as horrific as it once was, and that maybe we can find some ways to save money on taxes and make it a little better. So that is something we actually do. We'll run through calculations, and as John says, John often suggests, hey, what's it going to cost? What's it going to be in compliance? Well, you can find that answer out with us. You can find out the answers like, okay, we could, prepare your returns, figure out what it is. You can decide what you want to do with them.
Yeah. And what's it going to be in compliance moving forward?
And there you go. Right. So, right. Do you want to stay a U.S. person or not? What's going to be, because you got to stay. And that's the thing. Once you do this, you got to stay in current compliance. So I think with that, John is getting his coffee refilled, I think.
Yeah, and I'm going to have to go, gentlemen.
Yeah, you have to go too. So I think this might be a good time for us to sec off. I did want to tease our next topic, though, because we have that coming up on Friday, right?
Yes.
And what's that going to be on?
Well, I think we're going to talk about the current survey that's out there from the White House.
Oh, right. Oh, my God.
Yeah, let's talk about that.
Oh, my God.
I still say it's a good idea to fill out the survey, but there's a number of elements that need to be discussed in regards to the survey.
Yeah, and I would say, okay, so we'll hit that survey. And, when I looked at that, Keith, thank you for sharing that with me. Yeah, the White House published a survey, and it doesn't look like they're actually caring about the issues affecting people. Rather, it looks like they're just collecting a mailing list to politic from, which would actually
some thoughts on that maybe there's a long-term strategy. Who knows?
Yeah, and I just looks like it might be a violation of the Hatch Act as I looked at it. I'm like, this is not looking to help people. This is just looking to get people there. So join us on Friday as we discuss the White House's interesting survey that they have, and I think it exposes a lot of the problems that everyone is dealing with. So with that, for John Richardson, Keith Redmond, this is Anthony Parent of IRS Medic. I want to thank everyone for joining us today. Appreciate the comments as always. Thank you so much for joining us today.